during PCCD-led meetings. The Commonwealth has not approved AI note takers, and therefore, if you use a service like this, please disable or turn the feature off during this meeting. If AI note takers are not disabled and they appear as a participant in this meeting, they will be promptly removed by PCCD staff, and we thank you for your cooperation in this regard. Just a couple of other housekeeping matters this morning. We have a large amount of content, so there's no formal break built into our meeting agenda. Please step away briefly as needed. And then finally, this meeting counts for 2 hours of training toward annual PCCD requirements. As a reminder, direct service advocates and staff need to have 10 hours of training per calendar year. The OVS Training and Professional Development Standard provides further guidance with training requirements. And so, with all of these things in mind, we will go ahead and get started. And thank you again for spending part of your day with us. Our first presenter this morning is Emily Ruzicka, and Emily is going to talk with us about the 2025-2026 RASA and VOJO funding cycle.
Thanks, Heather. My name's Emily. I'm a victim services specialist here at the Office of Victim Services, and I'm just going to go over some general updates regarding the 2025-2026 RASA VOJO funding cycle. So I'm just going to start with touching briefly on our current 2025 awards. Then I will talk about our 2026 RASA VOJO continuation application and what that will entail. So all of our 2025 RASA VOJO projects were effective as of January 1st, 2025. Award letters for these grants continue to be distributed as the approval process continues. As a reminder, once the grant is awarded, invoices can be submitted for reimbursement dating back to January 1st, 2025. Quarter one program and fiscal reports, they are going to be due April 20th for the January 1st through March 31st reporting period. As a reminder for the quarter one program reports, all victims are considered new victims. Later in this meeting, we will hear some updates from our OVS data collection manager, Josh Kaminsky, who's going to provide some important updates regarding our RASA and VOJO program reports. So as you may remember, the 2025-2026 RASA VOJO funding announcement, which was released last year, indicated that all grantees will need to submit what we call a continuation application for year 2 of the funding cycle. So 2025 is considered year 1 of the funding cycle. 2026 will be considered as year 2. PCCD anticipates that the application process for those continuation applications will begin sometime in late spring or early summer of this year. So we will make an announcement to the field that the continuation application process has begun. So just be sure to keep an eye out for an email blast from us, and make sure to continue to review our OVS newsletters for reminders and updates regarding the application window and other important information. And as another reminder, year 2 allocations will remain at level funding with no increases or decreases. And additionally, with the continuation application, the RASA allocations will no longer include variable penalty assessment dollars. As part of the application process, each district attorney is required to complete the RASA VOJO funding recommendation forms. So the funding recommendation forms indicate which victim service programs within the county or service area are recommended to receive the RASA and VOJO funds. PCCD will contact each district attorney once that application window opens. These forms are a regular part of the application process, and the procedure to complete the forms will be the same as it was during year 1 of the funding cycle. So PCCD, we will reach out to the district attorneys as necessary to obtain those forms in a timely manner, just to ensure that there is sufficient time for the programs to submit their applications. So once the window opens for the year 2 continuation applications, you're going to go ahead and log into eGrants to complete your application. So you'll see here I have a screenshot from eGrants. What you're going to do is find your regular year 1 application in eGrants. You'll see I have an example here. The original application is 44531. And you will see that Create New Continuation button right above the Create Project Modification Request button. So once you click that Create New Continuation option, eGrants is going to generate your application for year 2. It's going to generate your continuation application. You'll see that the original application and the continuation application are going to be linked in eGrants. So the regular application that was created is 44531. The continuation application is going to be 44531-2. So they are going to be linked together in the eGrants system. Once you create that continuation application, the information that was inputted into the original application should populate into the continuation application. If there are any changes to your grant narrative or budget for year 2, you're just going to go ahead and make sure that those changes are reflected in your continuation application. So you just want to make sure that you're removing anything in that application that specifically mentions year 1. When you go to do your budget in your continuation application, that budget section, the information may also populate over from your original grant application. So that will just need to be revised to reflect only information pertaining to the year 2 budget. So we are working on a continuation guide as well as a toolkit to help programs through the completing of the continuation application. These materials will be distributed to the field by OVS via email. So that's another thing that you want to keep an eye out for. Make sure that you closely read our continuation application guidelines, as there are some things that may not be required for the continuation application that were required for the initial application. An example of that would be job descriptions. So if there are no changes with your program's job descriptions from year 1 to year 2, then you don't need to submit those same job descriptions in your continuation application. So hopefully that should help to save some time while completing the continuation application. And lastly, PCCD is moving to an e-signature format with all grant applications submitted in eGrants. So the 2026 RASA VOJO application must be electronically signed in eGrants for the application to be considered complete. At least one person from the victim service programs will need to have what we call e-signature capability. And we know this is brand new, so we are going, our RASA VOJO continuation guide is going to contain instructions on how to acquire e-signature capabilities, as well as step-by-step instructions on how to complete the e-signature process. So all of that information is going to come out to the field from us. Okay, Heather, do we have any questions in the chat about our...
We do not have any questions specifically to your content and overview, Emily. If anybody has a question concerning 2026 continuation applications at this time, please go ahead and put that in the chat.
Yeah, and if we don't answer your questions or you have any questions during the actual continuation application process, you can always email your program or fiscal staff assigned to your grant. You'll also see my email here on our slide. So if you have any specific questions, you can also just reach out to me and I will definitely assist you with anything you may need.
Emily, we did get one question. Valerie writes, can we set up e-signatures now with the e-grant system?
Yes, you can set them up now if you are aware of how to do that, but otherwise, if you're not aware of how to go about that process, because it is live, we will send all those directions out to you within the next month or two or three.
Yeah, the e-signature information and how to get that started in e-grants will be part of our RASA VOJO toolkit. And then Emily Adrian from Cumberland County wrote, for county application submissions, that e-signature should be a commissioner, correct?
Um, I don't,
Yeah.
yeah,
Normally,
Heather.
Adrian, you would have one of your commissioners would be the signatory. And if it makes the most sense to use your president commissioner, go ahead and do that. Okay,
Yeah,
and
so,
I think we answered Adrian's questions. There are no further questions in the chat at this time.
okay, thank you so much, everybody. I appreciate your time.
Hi,
Thank
Heather.
you.
Heather,
Thank
it's
you.
Brian. I'm sorry to interrupt here real quick. Just a reminder to folks, if you have the AI note taker on, please disable that. Otherwise, we'll have to remove that from here because again, it's not permitted by the state. So if you could please do that, we greatly appreciate it. Thank you, Heather. Sorry to interrupt.
Okay, no problem. Awesome. Thanks for that reminder, Brian. So our next presenter then will turn things over to Stacy Brenlinger. Stacy is our Deputy Director with the VCAP program at the Office of Victim Services, and she's going to provide a 2024 overview of VCAP for us.
Good morning, everybody. As Heather said, if you don't know me, I'm Stacy Brenlinger with the Victims Compensation Program. Before I get into the statistical overview, there were just some reminders that I wanted to go over in regards to victims compensation. Sometime last year, I think it was late summer, early fall, we had determined that the completion of a forensic rape exam is now considered proper authority for victims of sexual assault who have that exam done to be eligible for a regular claim. As you know, for a regular claim, the crime does have to be reported to a proper authority, but now having that forensic rape exam completed allows them to open a regular claim, which then allows them for the cost of medications, relocation, counseling, loss of earnings, any expense that they might have that wouldn't have been paid under the forensic rape exam. Also want to remind folks that we have our claim forms translated. I think we're up to 13 languages. They're all available on our website. So if you are working with a limited English speaker, you can get our claim forms in their language to help them. And if you indicate the language, we do send our acknowledgement letter and checklist and other letters to them in the language that had been indicated. We also have our claim form in Braille, which is available by contacting the program, and we would be able to send you a copy of that claim form in Braille. One of the projects that we're working on this year with VCAP is we do have our online claim filing system for victims or claimants who decide to self-file. It's web-based, but we are working on having our online claim filing system also translated into Spanish. So if they're a Spanish speaking individual or reading individual, they can file that claim on the website in their language. We are also in the process, we've had an evaluation survey forever. Unfortunately, our response rate to that survey is very low. I think we send out about 13 notifications of the survey. And we get about 1% response rate on that. So it's extremely low, but we are always interested in getting feedback, both positive and negative, just so that we can, work on improving the program or know what we're doing well. So we are in the process of moving that to a different platform. It'll be through Qualtrics. We're hoping to increase that completion rate. It is currently now located in Dave. If a victim or claimant goes to log into the case management system, Dave, to see the status of their claim or whatever it might be, there is a link there for the survey, for them to take the survey. And that's where it will continue to be located. And then we'll be working with some programs across the state just to kind of help pilot the distribution of the notification of the survey, so that we know the best way to get the word out to victims or claimants who we've processed a claim for on how to complete that survey. And lastly, before I get into the statistical overview, I just wanted to remind everybody too that we do have trainings available in regards to victims' compensation that are WebExes that are available. They're live trainings that are done by Mike Reich. He offers a bunch of them every month. You can always sign up for those. And we're also available to do in-person trainings if you would like an in-person training. And I often get a question, how many folks do you have to come do an in-person training? I don't care. I've gone and done in-person trainings for 2 people, and I've done them for 30 people. So as long as there's somebody there to listen to me, I would be more than happy to do a training. And on that note, also, we have done trainings for Area Agency on Aging, funeral homes, law enforcement, other entities that might not so much be in the victim service realm, but are a part of it and would benefit from knowing about VCAP. So if you have anything like that, please reach out to us and we can certainly get something scheduled. Okay, so for our statistical overview, this is for 2024. For our claims received, processing time, and claim payout, our regular claims did decrease slightly from where we were in 2023. Our forensic rape exams also decreased. However, our sexual assault counseling claims increased by 51%. And just a reminder, our sexual assault counseling claims are claims that came about in 2019 as a result of legislation that was passed. And this is for victims of a sexual assault who did not report the crime, or they might have reported the crime, but they didn't file a VCAP claim in the required time frame. They are eligible to file the sexual assault counseling claim and to be eligible for counseling expenses. However, it's only counseling expenses. So unlike our regular claims, they're not eligible for transportation, loss of earnings, or anything like that. It is really only the counseling expenses, and it's only for the direct victim. So we have seen an increase in those. For our processing time, we are at about 13 weeks in 2024 for our processing time. That was a slight increase from 2023. And for our claim payout, we paid out over $15 million in 2024, which was almost an 11% increase from 2023. That 15 million is the highest that we've paid out in compensation claims, and we fully expect that number just to increase next year and the year after as well. So for number of first-time and supplemental awards, our first-time awards are those awards that, we've received a claim, we have a medical bill, or we have loss of earnings that we can pay, so we're making that payment for the first time on that claim. We had an 8% increase in our first-time award for regulars. We did see a decrease in our forensic rape exams, and our sexual assault counseling claims had a 22% increase of first-time awards from 2023. Our supplementals are those claims that we've already made our first time award on, and now we're paying additional medical bills, or we got what we needed to pay loss of earnings, so we're going to make another payment on that claim. Our regular claims, we saw an increase in that. For a forensic rape exam, there was a decrease, which isn't really concerning because our forensic rape exams are usually what we call one and done claims. We pay them and there's no supplementals because there's only $1,000 that we can pay on them. However, our sexual assault counseling claims, we did see a 47% increase in the number of supplementals we are paying on those claims from 2023. And the reason for that is because those are typically ongoing counseling that we pay once a month. So as long as they're continuing to go to counseling, we'll continue to pay on those claims until they reach the maximum cap. So Dave logins and claim filing. Providers have the ability to log into Dave, and this includes medical providers or victim service providers, have the ability to log into Dave to check the status of claims that they've helped file or medical bills that have been submitted, like that the hospital can log in and check, and they can check the status of their individual bill. We encourage providers to log into Dave to check that because it can be done at any time of the day. They don't have to wait until our office is open and to speak to somebody. They can check that at their convenience. And it also just, again, it helps them get the information right at their fingertip and not have to wait for to speak with one of our client service reps. Claimants can also log into Dave and check the status of their claim, what documents might have been received, what we're still waiting for. If we've made payments, they can see what payments have been made. And again, we encourage claimants to do that as well because they can check that at any time without having to wait to speak with somebody. Also with the provider login, the claimant logins, it's probably been about a year now, but individuals do have the ability to log into the claim and be able to upload directly into that claim documents that they might have normally mailed to us or emailed or faxed. They can upload them directly into the claim. We get a notification right away that something has been uploaded and we're able to see that. So we encourage that to be used as well, rather than having to wait for the postal system or, a fax to get to us. So the online claim filing, this is for individuals who self-file. And again, they use that online claim filing where I had mentioned we're also looking into making that available in Spanish. They self-file through that system. We saw a 14% increase of claims being self-filed online. And then we also have our app that individuals can use, download, and file a claim through the app. The app also allows them to check the status of their claim. They can log in and check their status. They can find help in their county through the app as well. We had a decrease in the number of claims being filed through the app. I think it's probably just a lack of knowledge about the app, and sometimes it's not always easy to enter a claim on your phone through the app. So could be a number of reasons why that decreased usage. So for our top 5 expenses and crime types paid in 2024, our forensic rape exams made up 22% of our overall payment, followed by funeral home and cemetery expenses, counseling for minor victim, loss of earnings for individuals who weren't able to work as a result of the crime, and then our stolen cash claims were our 5th highest expense paid. For the top 5 crimes, it again is our forensic rape claim forms that come in. Those rape crimes make up 25% of the crimes paid, followed by assault, homicide, sexual abuse, and then theft by deception. And theft by deception is related to our stolen cash claims. And just to break down by county, and if your county is not listed here and you're interested to see where you kind of rank with number of claims filed or the amount paid, please feel free to reach out to me. I can certainly get that for your individual county. But for claims filed, Philadelphia made up 22% of our overall claims filed, followed by Allegheny, Lancaster, Montgomery, and then Dauphin County. And for counties paid, Philadelphia, 29% of our overall payment went to Philadelphia, followed by Allegheny, Montgomery, Lancaster, and then Delaware. But again, if you are interested in your county information or even just your specific program information as well, we can certainly get that for you if you reach out to us. And then any questions about what I went over or any other questions about VCAP?
No questions right this minute, Stacy. If you have a question for Stacy, please go ahead and put it in the chat.
And if you think of one afterwards, like I said, please feel free to reach out to me or to the program. We'd certainly be happy to help.
Awesome. Thank you so much, Stacy.
Thank you.
So this morning, OVS is pleased to have 2 guest organizations presenting for us. The first is from Mothers Against Drunk Driving, also known as MAD, and we will be hearing from Linda Spasato and Paige Carbone, who work for that organization. And I think Linda's going to kick it off for this next presentation.
Hi, everyone. Can you hear me okay?
Yes, we can hear you, Linda. Thank you.
Okay, I just want to apologize if I'm coughing at all because I'm dealing with bronchitis. Hopefully I'll be okay as I go through the presentation. Thank you. Okay. Is Paige on? I don't think she's on yet, so I'll start. At MAD, we always start with a mission moment. It's to just make everyone realize why we are here. So I'm going to start with my story and what brought me to MAD. As I waited for my daughter Bernadette to come home like so many times before, little did I know that this night I would get that phone call that every parent fears. Your daughter has been in an accident. Please come to the hospital immediately. You get in the car and you are driving to the hospital and you can't get there fast enough. And you are praying and praying that your child is okay. You get to the hospital only to hear those 8 words that will change your life forever. I'm sorry, your daughter didn't make it. You go into shock. You can't think clearly. You can't comprehend what people are telling you. You are confused and you don't know what to do because it's not something you can ever prepare yourself for. I knew I needed to see my daughter, to tell her I loved her, to hold her, to kiss her, to tell her mommy was there. However, all my love could not save her. Then I had to go home and tell my other 3 children that their sister was dead. You feel like you're going crazy from this intense grief, so deep, so painful that you don't think you're going to make it, and at times wishing you don't. And then you have to gather every bit of strength you have left to make arrangements to bury your child, something no parent should have to do. But you are given no choice. You must do it. And then you find out your child has died because of someone else's actions. Your child has died because someone chose to drive impaired. You are angry at the driver, angry at God, angry at the whole world for being able to go on without your child because you can't go on. How are you supposed to go on living without your child? When someone you loved is killed suddenly and violently, the grief is intense, complicated, and long-lasting. When your child is killed, the hopes and dreams for that child are gone. You feel empty, and it's hard to find the desire to go on. And through all this, you are now thrown into the criminal justice system. Thank goodness I had a MAD advocate to take my hand and walk me through it all. MAD advocates offer support from the moment the crash happens to years later, because you spend the next days, months, and years mourning the loss of your child and trying to build a different life. But every birthday, every holiday, every death anniversary, that intense grief creeps back, and that longing to see your child, talk to your child, hold your child, never leaves. Matt has always been there for me to help me survive. I started attending support groups. Being with others gave me solace that I was not alone. Attending candlelight vigils and then sharing my story with students and at victim impact panels also gave me strength to move forward. Finally, after years, I became a MAD advocate, turning my pain into purpose. That's what MAD does. We help survivors survive. Next slide, if you can run the movie, please.
Hold on 1 second here.
What would you do to protect the ones you love? 4 decades ago, one woman's courageous fight against drunk driving sparked a movement that transformed our nation. Today, MAD carries that mission forward.
We are at an important point in our history at MAD.
But impaired driving hasn't gone away.
Every 78 seconds, someone is killed or injured by an impaired driving crash.
If I only knew that the last words that I would hear my baby girl say was, "Bye, Mama, I love you," I would have never let her went to work that day.
So MAD is leading the charge for anti-drunk driving technology, prevention, support for victims and survivors, and stricter laws. We're more determined than ever to end impaired driving in our lifetime. But it's going to take all of us doing our part, committing to never drive impaired, and reaching communities all across the country. We'll do anything to protect the ones we love and one another so we all get home safely.
I will fight till the day I die to make sure that this doesn't happen to anybody else.
Think before you drink. It changes lives. The thing about it is, we can make change.
We're up for the challenge. Are you? Impaired driving ends here. Join the movement.
Linda, we'll get your PowerPoint up in just 1 minute here.
No problem.
Brian, I think we can go to slide 4, please.
Yes.
Thank you.
Okay, thank you, Brian. So MAD's mission is fourfold: to end drunk driving, to help fight drug driving, to prevent underage drinking, and our best kept secret of all, which I'm going to talk about today, is to support the victims of that violent crime. Next slide. So I just want to talk a little bit about the history of MAD because we're 45 years old now, so some people might not really know how we started it and where we're going from here. So MAD began in 1980 with a mother turning her grief into action. Candace Leitner's daughter, Carrie, was walking to a church carnival at the same time a 3-time repeat offender out of jail just 2 days from a 4th DUI arrest was barreling down the road. He hit Carrie from behind, throwing her out of her shoes 125 feet, then fled the scene, but later was arrested and charged with her death. Next slide, please. 4 days after Carly's death, Leitner started up the grassroots organization to advocate for stiffer penalties for drunk driving. But we have to remember it's 1980, so there's no internet, let alone social media. So what she did was she posted a note in her local grocery store saying, "Is anyone a victim of a drunk driving crash? Come to my house for a meeting." So it's 1980, and there's 25,000 people being killed in alcohol-related crashes then. So people came, and that's how it began. Her goal was twofold. First, to raise public awareness of the serious nature of DUI, and second, to promote tougher laws against it. Next slide. So the scope of our issue is really to reach and serve more victims. Each year, 10,000 people are killed and around 300,000 people are injured in drunk driving crashes, and this doesn't include drunk driving. In Pennsylvania, in 2023, 308 fatalities, 111 injuries, and 4,171 property damages alone. Injured and property damage victims are the most underserved victims of DUI. Next slide, please. You will hear me use the word crash throughout this presentation. MAD does not use the word accident when referring to impaired driving because it's a choice, a violent crime, and it's 100% preventable, especially today with all the drive sharing options we have. Next slide, please. So I talked about the beginning of MAD and how there was no social media to raise awareness. So Candace and all those supporters, they protested to get their message across. That's what you did in those days. You see those moms holding up those signs, protesting, trying to get everyone's attention. But because of this, there's many people who have a bad perception of MAD. And that's also caused people not to reach out to us because they don't even know that we're victim service providers. So people think of us as anti-alcohol organizations, not anti-drunk driving organizations. We're too political. They think we go after the social drinker. They don't like the fact that there's mandatory prison sentences that we fought for. They think we're prohibitionists, that we don't want anybody to drink at all. And, in this country, if you're 21 years old, it's legal to drink. Some people think the campaign against drunk driving has been won. They say, well, who doesn't know not to drive impaired? And mostly a lot of people think we're a bunch of angry moms. And that's because of those early days when they were protesting, and it was mostly moms. But that's not the way it is at all today. There's many people involved in MAD. Next slide, please. So today I'm going to talk to you about MAD Victim Services, which we think is our best kept secret. Next slide, please. Some of the terminology that we use in MAD is a victim or survivor of MAD is someone who self-identifies bereaved and or injured, property damage, or underage drinking, fatality, or injury. We call our advocates victim service specialists because we're professionally trained staff or volunteers who provide services and case management. And we are there for the long-term needs because we feel there's no timeline in grief or loss. And MAD provides all victim services at no cost to victim survivors, families, and the community. Next page, please. Oh, thank you. Long after the crash, survivors, family, and friends continue to feel the impact. So here are some of our services. We have a 24/7 helpline. We provide emotional support, guidance through the criminal and civil justice system, court accompaniment when available, information and help in applying for victim crime compensation benefits. We help prepare victims for victim impact statements. We assist them in filing for restitution. We provide supportive material on victimization topics. We give them resource referrals, and we hold a monthly virtual support group. How victim advocates can help. So we provide direct support to victims, answering a lot of questions and explaining the process. We take the time to answer all their questions. We provide assistance on cases where you can't bring charges. Charges are dropped or after the court case. Many times there are no charges and people have a hard time understanding the whole process of bringing charges and when they can be charged. And we take the time to explain it to them, update the victims on all their changes. We connect to all the family members that want our support, and of course the helpline and resource materials. So what helps? We have to take the time to talk to the victims and survivors about their concerns. Sometimes they will call us right after a crash, even before charges are filed, and have many questions. Sometimes they're still in a state of shock and need to have things explained to them many times to comprehend what's happening and the processes and the many challenges that will arise. Next slide, please. Injured victims are probably the most underserved population of DUI victims. Oftentimes there's a crash, but the victim did not receive immediate medical attention. So the police may not even know the victim was injured because maybe they sought medical attention later or the next day. It doesn't matter how it occurred. There may not be a record of that injured victim. Also, if it's not classified as a serious bodily injury where aggravated assault charges are filed, the district attorney's office may not even be aware of a victim. So this causes the victim to not be informed, to not have any information on VCAP or restitution or any other resources. And many times the defendants are only charged with the DUI, no jail time. And this sometimes leaves the victims feeling that their injuries are not important. They need to have the system explained to them, and they need to have their concerns acknowledged. It's very important to have their concerns acknowledged, and we certainly spend the time speaking with them about all the issues that can arise. Next slide, please. Another underserved population is property damage, whether it be car or property damage to their house. Many times the defendants have little or no insurance. Victims and survivors may not have adequate insurance either. And sometimes the victims and survivors only receive book value for their car. What we hear the most is, my car was paid off. The value of the insurance company is telling me that my car is worth a lot less than what it's worth to me. Now I have to go out and get money together to either buy a new car or get a car loan, which I didn't have prior to this crash. So restitution doesn't always cover all these expenses, and these people are left with out-of-pocket expenses at no fault of their own. So the challenges to these people are if they don't know there's a victim in the crime, there's no notification, they don't get a chance to have a victim impact statement, they don't have any access to restitution. Sometimes the cases are never prosecuted, and if they are, the sentences are very low. Sometimes just charged with the DUI, which sometimes really upsets the victims. And, there's long delays in the criminal justice process, so they get very frustrated. And the most important thing is a lot of these victims don't even know that they have services available to them. So let's talk about some of the challenges to all the DUI victims. One of the hardest conversations to have with a person who has lost a loved one is the sentencing for homicide by vehicle while DUI, that it's only 3 to 6 years. They feel that their loved one was murdered, and it takes time and patience to help them understand the law, and this is the sentencing that these people are going to get. In many cases, when this happens, sometimes this is when the victims choose to go on and make changes to the law, just like Candace did when she started in 1980. In the case of injured victims, many fear that the defendants will only be on probation, and sometimes that does happen. So we have to take the time to explain the criminal justice system, and it's a long process, and a lot of patience is needed while they go through the system. People will go on the internet today, and they'll search those case dockets, and then they'll want to know why they weren't informed of the changes that they see on those dockets. And we all know that every county is different, and people can't depend on those dockets to tell them what is happening, and the communication must be with the DA's office. Also, some people have a difficult time when they hear the word plea deal. They want to have their day in court in a trial. We must support them, but also explain the process and how it works and understanding the criminal justice system. Plea deals happen every day, and we really go through the time to explain to them what it means when a plea is negotiated. Hearing testimony and viewing photos in the courtroom can be very difficult for people. Sometimes people are hearing for the first time the details of how their loved one was killed or injured. This is very difficult. We always try to explain to them prior to what's going to happen, but they need to know they have the option to leave that courtroom if they wish during this testimony. Many victims often tell us also that people tell them they need to get over it. They need to move on. Or they're lucky to be alive because they've only been injured. But every victimization is personal to them, and they deserve to be validated. And of course, when you lose a loved one in a DUI crash, there's really never any closure. We just try to help them find a way to survive. Next slide, please. So other challenges are they want to know why the driver hasn't been arrested. They think that the person should be arrested immediately after the crash. And at times we have to really explain to them the whole process, how the police or the detectives have to gather the evidence before their arrest. Sometimes they're afraid they're never going to be arrested. They really have a hard time with people being out on bail. And sometimes these people are allowed to continue to drive, which really upsets the victims. The victims think that they're going to have their day in court. They think that it's like them against the defendant instead of the Commonwealth against the defendant. And you really have to explain the process to them. I know when I had my case, I had never been in a courtroom in my life. So I had no idea how the process worked. So it's important to take the time to explain the criminal justice system. They think that plea agreements are bad. So that's another thing that we really try to explain to them. They have a fear that the driver will flee while they're out on bail. Although rare, it does happen at times. So I can understand their fear. And a lot of times they just feel like they're being treated differently than other cases because they look at it as a DUI homicide, as murder. They feel that their loved one has been murdered. But we have to explain that that's not the charges that will be charged with. Next slide, please. Okay, let's talk a little bit about civil litigation because this is a very important part to DUI victims. So friends and family suggest hiring a lawyer sometimes before criminal charges are even filed. So when there's a crash, many times the first thing friends and family will say to them, get a lawyer and sue. So they call an attorney, maybe a family friend or someone they know, and there hasn't even been charges yet. So now they have this civil attorney, and many times they think this civil attorney is representing them in the criminal justice case. So we have to really go about explaining to them the difference between civil attorneys and prosecutors. And it's difficult, but you have to just explain it to them so they understand the process. And even though the civil attorney may be part of the criminal justice process, they are not representing them in this case. I think the hardest conversation are the ones we have when we have to explain to victims that just because someone was driving impaired, the impairment may not be the cause of the crash. I remember one incident when a young man was dressed in dark clothes at night riding his bicycle and he ran right in front of a car. The driver had no way to see him or stop. So there was no charges filed against him other than a DUI. And the family had a very hard time accepting this. They wanted someone to be responsible for their loved one's death. So now there's no criminal charges and no civil suit. So you do your best to explain that the police or detectives must follow the evidence in the case. And sometimes there will not be any charges. With civil litigation, there's also dram shop insurance that the establishments carry. But sometimes you never know where the drinking establishment was. So there's a civil suit and they want to know where the person was drinking so they can sue the bar or a drinking establishment. And sometimes victims will, the civil attorney of the victim will choose to make a plea agreement where the defendant will acknowledge the drinking establishment in exchange for a lower sentencing. It is not our place to judge their decision, but to support them with their decision, because we don't know what their financial position is, and they might be doing what's best for their family. We encourage all victims and survivors to apply for VCAP while they're waiting for civil litigation. However, many civil attorneys discourage victims from applying for VCAP. They tell them, you have to pay it back, and it's a lot of trouble, and it's a lot of forms to fill out. But we know that some of these civil cases may take years to come to fruition. And in the meantime, these people are, in need of financial help. And also, many of these impaired drivers, they often don't even have driver's license, auto insurance, they're not financially able to pay, or they're in prison. So there may not really be a civil case. So we really try to encourage all victims to apply for victim compensation. So what helps? Hundreds of victims and survivors were interviewed and asked what helped them the most by being involved with MAD after their crash experience. The top 3 answers were being able to talk about their crash over and over again, having all their feelings and relationships accepted, and being with others who have similar experiences. MAD has a wonderful resource library that we hope you all will take us up on. We have wonderful little brochures about adult grief, helping children cope with death, teen grief, coping with injuries, resources, understanding the criminal and civil justice system. And we would be happy to send these to your victims or to you. If you feel that it would help, we would certainly be more than happy to send them out. I think the Victim Impact Statement booklet is our most requested, and we've been told how very helpful it is for victims when trying to write their victim impact statements, not only for themselves, but of their family and friends. It's a wonderful little guidebook that helps them understand what a victim impact statement is and how to create one. And once again, we will be more than happy to send that out to anyone who needs it. So beyond the crash, what are victims and survivors passionate about? They want to make a difference a lot, prevention. And that's really how Candace Lightman started. They want to honor and remember their loved ones or their own experience. It's very important. They don't want anyone to forget their loved one. Supporting and connecting with others who shared experience is very important for them. And many of them like to share their stories. And we have many options for them to share their story, because sometimes repeating that story can encourage them to process what has happened to them. Next slide, please. So we have a 24/7 helpline. People call our helpline, and an advocate at our national office does an intake and sends the information to the designated person in that state, and we follow up 24 to 48 hours later. Next slide, please. We also have a live chat. I encourage everyone to go onto mad.org's website. We have a live chat where once again, there's people in our national office that gather the information and then send it to the state for follow-up. We also have our victims only Facebook page. After answering a questionnaire, victims will have access to the Facebook page where they can connect with DUI victims all over the country to share their stories and experiences. They ask for advice on such things as what do they do for their memorials. They post pictures of their loved ones, and they get additional information and support. So please visit our mad.org website for information. And now I'd like to turn it over to Paige because she's going to give us information on other MAD programs. Are you with us, Paige?
I am here. Good morning, everyone. Can you all hear me?
Yes.
Yes, we can hear you, Paige.
Great, great. Okay, so just going to take the last couple of minutes for Mad's presentation and just go over a couple of prevention programs we have. This is another piece of our mission delivery, in the field programs. So we have victim services and prevention and education programs. Wanted to let everybody on the call know that our programs start at 4th and 5th grade and go all the way up through high school, as well as working with parents as part of the process. So two of our newest programs that I want to highlight today are our promposal. And this is an opportunity that we go into schools and we work specifically with juniors and seniors to take a pledge to be safe and drug and alcohol free on their prom night. So this is one of our newest programs, and our second newest is Mad Spirit, and this is a program centered around homecoming. So this is done in high school programs, and as well we're focusing on the importance of educating students on the risks of underage drinking, and especially around homecoming time. If you go to the next slide goes a little bit more into depth about our power programs. And so you all will receive a copy of this presentation. Our three power programs are Power of Me, which are for 4th and 5th graders. So a very targeted understanding with terminology that young children can understand about just alcohol in general, and being safe with alcohol, and understanding what that looks like. So this is aimed toward preventing underage drinking, reducing alcohol-related injuries and death, and this is for 4th and 5th graders. Power of Youth is for middle school and high school students, and this empowers teens to take a stand against underage drinking and drug use and never ride with an impaired driver. And then the Power of Parents program are for parents and guardians, and this involves them in the process. So, having conversations and involving parents in the process is something that MAD feels is very important. So we have our three power programs, and these programs are all offered free of charge, as I said, in schools and in communities. Next slide, please. Okay, and then the third pillar of what we do in our mission delivery programs is our development and community engagement. And so this is where, as a 501c3, we partner with different community organizations, we partner with different foundations, and work to raise money and funds for these programs. So wanted to just point out that in the state of Pennsylvania, we run two events that are our signature fundraising events. So we have our Pittsburgh Walk Like Mad and 5K Dash happening on June 8th. And then in the fall, the date is TBD. Looks like we will be securing that date very soon. And that is our Walk Like Mad. And this is an opportunity for not just for folks to come together and to raise money. Of course, that is a very important piece of what we do, but it's also an opportunity for us to honor victims and survivors at these type of community engagement events. We come together, we have mission moment speakers who share their stories, as Linda did today, and it's a wonderful opportunity to bring more community partners together. Next slide. We have the best volunteers at MAD. And one of the things we always say is that there is a place for you at MAD. So if you are a senior citizen, if you are a student, everyone in between, there are a bunch of different opportunities to volunteer. And our next slide shows those. But, these different opportunities can happen at different times a year. So if folks are available, and feel the want and the desire to give back in a volunteer capacity, these are the different areas that you can do so. And these are all on our website at mad.org/volunteer, and gives a little bit more detail and information. Some of these opportunities do require a background check. But again, the important thing to just note here is that we are always interested in working with people in the community to secure volunteers, and that there is a place for everyone at MAD, no matter what your interest and no matter what your time, what your timing constraints may be. Okay, I think maybe we have one more slide. Yep. This is our last slide, and just wanted to share again and reiterate what Linda said. We are a resource, and our goal is to really just touch the lives of those that have been impacted in some way, shape, or form by drunk or impaired driving. So if you are feeling, compelled to reach out, we do encourage you to do so. We have a wonderful staff in Pennsylvania and in our region and across the nation that can assist. So we have a 24/7 victim services helpline. We have information on our website. And then also, if you are interested in speaking to someone, you can always reach out to us via email as well. So we wanted to thank our partners at Pennsylvania VOCA today for inviting us to present and give a little bit more information about MAD. So thank you so much. And we're happy to answer any questions if folks want to reach out to us.
Thank you, Paige and Linda. Okay, so the date, we do have some Pittsburgh area folks signed up on this call. So the date is June 8th for the walk. The snow will be gone. We won't have to worry about winter weather by that point. But thank you very much, ladies. And Linda, thank you very much for sharing your precious Bernadette with us. I know she walks with you daily, so thank you again. We do have somebody just raised their hand, Laurie. Just raised their hand. Laurie, if you have a question or comment, could you kindly put that in the chat? We do have two questions that came in. Amy Sundstrom from Berks County wrote, how do we access your resource library?
Okay, so you can go on our website.
Yep, I'm going to get the links now and put them in the chat for them.
Awesome. Thank you.
You'll see that if you actually want a physical brochure, please send an email to pa.state@mad.org, and I'd be happy to send them to you. Some people like a physical brochure instead of a digital. I find that happens a lot with victims, so they can take their time reading and going through it. So if you want the physical brochure, just please send an email to me, and I'd be happy to send them out to you or directly to the victim that you would like it sent to.
Thank you, Linda. And I think Michelle from Fayette County had a similar question. Can I request brochures from your website? So And we'll be sending out this presentation to you all. Thank you for the kind remarks in the chat. This was indeed an excellent presentation. We'll go ahead and move on to our next guest presenter then. We are very pleased to have Penny Hockenberry from the Office of Victim Advocate with us this morning. Penny is the Executive Policy Specialist for OVA, and she's going to talk with us a little bit about the OVA registration portal that was established in line with Act 77 of 2022. And then we hope to also show our newly released legal standing video for court personnel. So at this time, I'll turn things over to Penny.
Thank you, Heather. I am incredibly grateful to be here today and that you all will take your time to listen to me speak. So I work for the Pennsylvania Office of Victim Advocate, which actually this year has been established for 30 years. Next slide. The Office of Victim Advocate was created within the Crime Victims Act, of which I'm sure all 95 of you that are attending right now is well aware of. On this PowerPoint, which you're going to receive also whenever they ship out the attendee items, is a URL link that you can click on to go view that act as well. Next slide. Our office takes crime victim rights very seriously, just like all of you. And our main focus is obviously to ensure that victims are informed, heard, accompanied, and restored. Next slide. Legal references specific to the Office of Victim Advocate, which I like to make sure is available for anybody, is like I previously mentioned, the Crime Victims Act, but also Title 61 under Chapter 61 and 73 in relation to the PA Board of Probation and Parole and the Board of Pardons. Next slide. Okay, so oftentimes, I don't always get the privilege to do presentations with those of you that already know this information. I oftentimes am speaking to other groups in regards to the differences and the similarities and all the things that make up victim services across the Commonwealth. And one slide that we have in here is basically explaining the difference between local victim services and the Office of Victim Advocate. Those of you that work in the RASA and VOJO funding know that pre-sentencing, court accompaniment, victim compensation, and restitution is all a big part of what it is that you do. When the individual that's incarcerated to a state sentence moves to a state sentence, our rights and services for victims kind of go into effect. So it's generally anything after sentencing, parole notification, program notifications for JRI-2, parole input assistance, accompaniment to in-person victim testimony, notice of offender deaths and escapes, and various other programs and services. Next slide. And when I say various other programs and services, that will be what this slide is breaking down for you. We provide victim notification for all sexually violent predators with a collaboration with Pennsylvania State Police. We provide notifications for all Board of Pardons cases that involve a victim, everyone. We provide advocacy with the Office of Attorney General for those counties in which victim services is not available. And we also provide something called the Address Confidentiality Program that if I had JR with me, he would probably take the remainder of my time to tell you about. In addition to that, some of the programs we focus on are restorative justice in nature, Inmate Apology Bank, the Victim Offender Dialogue. We have a Resilient Voices speaker program. And then within the institution, we engage in the impact of crime classes and victim awareness education to both develop the curriculum, but also to assist with the institutions in facilitating when it comes to gathering a speaker and providing any kind of background resources. Next slide. So one of the biggest things that I will say to you, to all of you, and to anyone that I see, is that the only way that we get the victim services work done across the Commonwealth is together. And our office truly believes in collaboration. We were pleased to be a part of the training today with PCCD as they're a huge stakeholder and collaborator with us. But every one of you is someone important in our world, and we truly believe that. Next slide. So I'm here to talk about the portal, right? About what comes with the portal is understanding this piece of Act 77 of 2022 and what the change created within the law and then created for us to facilitate. Obviously, Act 77 also brought other wonderful things. Victim compensation, which PCCD can tell you all about any kind of changes that would help a victim, as well as legal standing, in which I'm going to introduce a video about at the end of my presentation. But the biggest piece that I'm going to focus on right now for the portal is that Act 77 changed the responsibility for getting post-sentencing notifications from the onus being placed on the victim to the onus being placed on those of us on this call. We are now responsible to ensure that victim information is transferred so that victims are notified, so they're informed, so they're heard, and so they have the opportunity to speak if they so desire as well. So before Act 77, upon sentencing, many of your offices would send out a letter to a victim explaining the disposition of their case, that the individual that is incarcerated is going to a state correctional institute, and providing them with a registration form, which way back when I first started was a trifold, which kind of tells you how old I am, and now had then become a full sheet. And then you provide that information to the victim. The victim received it in the mail, and their job at that point in time was to fill it out and send it back to OVA. That was before Act 77. Next slide. Next slide. So after Act 77, and Act 77 occurs, we realize, hey, let's do this a better way for victims. Now how it's set up is that sentencing occurs and your office, wherever that may be, provides our office with victim information and contact information specific to that case. And then we let the victim know as soon as the individual is received at the state correctional institution that their information is available. If they wish to change anything, if they want to prefer how they notify, anything that it may be, we're going to let them know at that time, hey, we're going to facilitate the rest of your victim services at this level. We're going to let you know about parole. We're going to let you know about JRI-2 programming. We're going to let you know if sentences are shifted or changed within our Department of Corrections, etc. That's kind of our job. What it also doesn't mean is sometimes what can be confusing is that because our state also has something called SAVIN, there's an assumption that if you're registering a victim for SAVIN, you're registering them for our office, and that is actually not accurate at all. What you're registering the victim for is custody changes. So the victim will be notified in that electronic manner if they move from SCI Camp Hill to SCI Phoenix, but they're never going to get that letter that says, hey, the individual in your case is coming up for parole review. Here are all your rights. Would you like to provide any testimony? If you don't, that's absolutely fine. Would you like to get notification? And also, we're going to let them know ahead of time when that individual is being released and not, as SAVIN does, at the time of release. With that said, so we make this big change in the law and we're like, well, how do we do this, right? How do we make this be something that is a little bit simpler than receiving a trifold that every one of the people in your agencies have to rush around and fill out? And we decide the best option we could possibly do is to make a portal or an electronic avenue with which your offices can provide that information to our office. Next slide. So here's the registration form that I was talking about that indicates how gray my hair is. Next slide. And this is what we use now. So JNet was our go-to with being able to secure a place to place this portal that would ensure that the information we're transferring from your office to our office is safe and secure. With JNet, there's multi-factor authentication, and then there's also security protocols they have in order to keep their system safe. So many victim services agencies across the Commonwealth did not initially have access to JNet. Some do, and I think that's fantastic. But we partnered with JNet in an effort to, for those that already have access to JNet, to just add one more application they can access. For those that have never had access to JNet, to be able to get you to have access so that you go specifically to this particular application. So this little screenshot on the screen in front of you, if you can see it, sometimes I have to use my glasses. Once again, just a little bit aging as we go. You will notice that under the Justice Data dropdown, fourth or fifth tab down, it says DA Victim Registration Portal, and that is the link that you will click in once you have access, so that you can submit the information into the portal. Next slide. And this is what it looks like. Once you sign off on a disclaimer, you will enter your section. And keep in mind, we made sure there was a section for all 67 counties. So this section is specific to your county. And this is where you begin the process of entering your information. It is also a way for you to be able to view those that you may have previously submitted, so that, I don't know about you, sometimes at the end of the day, I forget what I've done when I start the next day. I have to drink a lot of coffee and remember exactly where I need to pick up again. And a registration simply starts with just hitting that plus sign. So next slide. There are 5 steps within the portal for you to fill out to essentially provide us with this information. Number 1 is related to the offender and court case. Obviously, we need to know the docket and the OTN and any offender identifiers that you may have. What this does is it makes sure we have the exact person that's incarcerated that's impacted by this case. And then you will enter the victim and survivor details, both 2 and 3. We're basically, because we're encompassing all the cases that are coming from across the Commonwealth. We have 65,000 registered victims, over 65,000 registered victims right now. And so you can imagine that there are duplications on names. There are even those that are very, very close and other personal identifying information. So we want to make sure we have the exact appropriate client associated with the exact appropriate court case. And then registration details that you can provide us with that help us know, obviously, if this is the minor in the case, if this is a case involving a homicide in which there are multiple family members, etc. And then you review that information, so it's all there in a snapshot for you, and you submit. Next slide. If you've ever wanted to know what it looks like on our end, this is it. So we have victim assistance coordinators assigned to various counties and regions, much of it based on volume, so that we can, number 1, do a better job of making connections and supporting the transfer of cases, but also just simply put, so that we're doing our work the appropriate way. And so this is what it looks like when it comes into us. We have a queue. It's based off of counties, gives you a total. And then as the individual that's assigned to your county begins to work on the case, they put it in review process so they can go through and make sure the T's are crossed, the I's are dotted, and add that information to our system. Next slide. And this is our contact information. And I provide this because though this was a snapshot and I've definitely had enough caffeine to absorb it today. We also know that sometimes when you're in that portal and you're working, or you maybe just get access, you're going to need further information. And so please reach out to us. We can literally have someone come and walk your office staff through using the portal if you so desire, or we can do it virtually as well, etc. We just want you to have the contact information so you are well aware. And then what you will be receiving from this training is also a resource guide we use to help with training or for new advocates that are being introduced to the portal. An FAQ on the portal so that you understand different pieces to it, and a flyer about my next discussion with you really quickly is something new that OVA is doing this year in regards to Crime Victims' Rights Week. The flyer basically speaks about how we believe that we're encouraging survivors, victim service professionals, and other allies to join together in kinship that week. And to let us know what events you're doing across the Commonwealth, so we can highlight them on our Facebook and social media. And then if there is a potential for you to provide us a short video clip of your event so that we can then marry those all together and basically show the Commonwealth all of the good work that's happening from Erie to Philly, from Pike to Green, because we believe so many things are happening, and the more we can highlight them and show that the good work we do together, the better off we are. And then in addition, let me pause and see if there's any questions in the chat.
We do have a question, Penny. This comes from Audria in Northumberland County. Let me another question came in, so I lost my place here in the chat.
It's fine.
Audrey writes, should we obtain victims' permission to input their data into the portal?
So this is what I recommend. I mean, obviously the law's changed pretty significantly, and it's a shall now. The DA shall provide this information to OVA. In our first notification to a victim, we definitely give them all the options so that they do not have to be a part of notification. But I have had many counties work with me, and they've adjusted the language in their disposition letter and other notifications, letting victims know that it will be a direct conduit. And there's absolutely nothing wrong with having conversations, obviously during accompaniment, etc., in which you're advising them that that information is going to be forwarded to our office. We don't wish to have anyone be unhappy with their process. And ultimately, if someone chooses not to, it's totally understandable. I think having that documentation, though, for yourself is pretty important. And it's also knowing that sometimes, and this is part of the reason why the law changed, the criminal justice system is so incredibly confusing. And so the one thing that happened way back when I started this job, and if I had $1 for every time it happened, I could have retired and you wouldn't even see my face today, is so many victims would call our office and simply say, I see the individual that was in my case in the grocery store, and I'm trying to understand why I wasn't notified, right? Because they didn't quite understand that your system doesn't directly talk to our system, right? Because in a logical medical world, I can go and get my mammogram, and they have all my medical information that's in my doctor's office, right? So I do understand why victims were inherently confused by it, right? And so the goal very much, I think, was to make this process be a little less confusing. But at no times do we want someone to obviously, they want to be done at sentencing. They never want to talk about it again. I think documenting that and making sure it's listed, that's pretty important. But the knowledge that the system as a whole is pretty incredibly confusing. I don't know about you guys, but every time I turn around, there's a new acronym, and we work in the system. So I can't imagine what a victim experiences. So any way to make it streamlined and less confusing is the best bet. But awareness and clarity is also important that we provide the victim. So definitely letting them know, notifying them, talking to them. I think that's always a big part of it.
Penny, we have a second question. This comes from David in Dauphin County. David is an assistant director there. He writes, could you talk about victim notifications of appeal? That's something I previously thought would come from OVA, but for a recent homicide case, again, this is Dauphin, I learned after the fact that it does not. We've since had to develop a protocol with our DA's office for timely victim notification of appeals and PCRAs.
Yeah, David, you are nail in the head. I think if we were going to conquer another issue, it would be that one. PCRAs have always been we are never notified whenever when an appeal is tapped into AOPC. We have direct notification, obviously, with the Department of Corrections and the Parole Board. Their systems kind of intermarry with ours. The only way we really touch AOPC is we're requesting docket information, and they'll provide it to us, but it's never refreshed, like without us manually doing that. So there is no clean way for all 67 counties outside of AOPC developing something to advise us of when there is an appeal process. Now, what we do get occasionally, and generally speaking, which is very unfortunate, is after the fact. We get a notice from the Department of Corrections if a sentence has been changed, right? So they went back, they did the appeal, and maybe it was successful or maybe it wasn't, and there was some modification, then that is when our office is notified, but it's definitely after the fact, and then it's not during. And it's something that all of my previous predecessors with victim advocates, or obviously I've been unhappy about and trying to figure out the best way forward with that. But because it directly is connected with the local AOPC county programming stuff, I don't have a perfect answer for you, but I would be glad to work with you to figure out a way that we could make that be whatever you're applying is applied across the 67 counties, or finding a way to make it be just a little bit cleaner and more efficient. I think sometimes the system is created in silos, and then things are attached after the fact and they're not all talking. So David, if you would, we can definitely get together and chat. I would love to, and figure out how we could go about making some change. I hope that answered your question.
Thank you, Penny. There was one other comment in the chat. This comes from Marie in Washington County. So I think because of time, we need to move on. But you know, Marie, if you wanted to contact Penny again, we'll be sending out the slides with OVA contact information. And David wrote a reply in the chat, Penny, that he would love to connect with you and maybe have a workshop done for the Dauphin folks.
Excellent. Can I introduce the video?
Absolutely. Go ahead.
Right. So OVA was thrilled to have the opportunity to work on this important project. It was a collaborative effort to engage the systems where crime victims seek justice. So we had OVA staff members do some background work to determine if service providers were aware of legal standing. We visited clerk of court offices in 41 counties. While AOPC assured us that the clerks knew and were prepared, we found out the information had not quite trickled down to the staff members most likely to engage with a crime survivor. Of the 41 counties where we questioned staff members in these clerk offices, 31 said they had no knowledge of legal standing. 7 said yes, they were aware, and 3 would not confirm or deny. OVA worked with staff at the PCCD to solidify the script, worked with a film producer who captures the heart of our work well, and relied on our partners in each discipline to find a speaker to address each service provider group. This was a collaborative effort that we hope will elevate the rights and needs of crime survivors.
American jurisprudence has always recognized and honored the idea that all persons who engage with the legal system should be treated fairly. This brief informative message supports these long-standing legal principles and addresses the rights afforded to crime victims in Pennsylvania, and highlights the legal standing options provided by Act 77, which became law in September of 2022. Crime victims have legal standing to assert and enforce rights enumerated in the Crime Victims Act. Similar to federal law, Pennsylvania statutes afford victims of personal injury crimes the opportunities to be heard prior to decisions being made throughout the course of the process. The law also requires criminal justice professionals to provide information and to keep victims informed. From what we know about trauma and how trauma impacts crime survivors, attention to the rights and needs of crime survivors at critical moments in the justice process helps to provide a sense of empowerment that is vital to the healing process. Let's take a look at where and when the law requires these impactful elements.
As officers of the law, we are often the first system-based person to engage with a crime survivor. This engagement is likely to be riddled with trauma. It is important that we understand that trauma impacts people differently, and there is no one right trauma response. Some crime survivors will appear visibly distraught, others may be numb or indifferent. All of these are common responses to trauma. It can be difficult, but in the midst of traumatic circumstances, we must remain ready to do our jobs and provide crime survivors with the support and guidance that the law requires. In crimes involving personal injury, the law requires us to make reasonable effort to notify victims of the arrest, the filing of a complaint, and any escapes from custody. The basic information we provide includes referrals to other providers. It creates pathways to healing and recovery from traumatic events. The application and information on victims' compensation is a huge step in the recovery process. This information helps crime survivors receive financial assistance for losses that occurred as a result of the crime. It is imperative that we understand how vital our role is in upholding crime victims' rights. When those of us who know better do better, we create multiple pathways for healing and justice.
The prothonotarians and clerks of courts offices throughout the Commonwealth represent a rich history steeped in tradition and jurisprudence. The Pennsylvania State Association of Prothonotarians and Clerks of Courts work to secure statewide uniformity across all Pennsylvania counties and to improve services to the public. It is important that we realize for the average citizen, coming through our doors is likely to be a traumatizing or at a minimum, a stressful event. We should be prepared to assist crime victims impacted by trauma with a trauma-informed approach. There are resources available to help you determine what that looks like for your office. Common principles of trauma-informed services include providing space for a person to be heard and providing options and allowing an individual to make their own choice. With the passage of Act 77 in September of 2022, legal standing became an avenue for crime victims to address violations of their rights in court. Crime victims have a choice on how to address these issues. Whether a crime survivor chooses to file their own motion, be represented by a private attorney, or request the prosecutor file on their behalf, prothonotarians and clerks of courts should be prepared to do our part by ensuring that the documents presented become part of the record. Assuring that crime survivors are comfortable engaging with court personnel is an important element in the judicial process. As the person behind the counter or desk, there is an assumption of power perceived by those on the other side. Let's stay committed to harnessing our power into excellence in the service provision for the benefit of all the citizens of the Commonwealth.
Prosecutors are responsible for all phases of the criminal trial process. And with that responsibility comes duties and obligations to the crime victims impacted by the cases we prosecute and the cases we choose not to file. As attorneys, we are familiar with the Crime Victim Bill of Rights, and we are committed to upholding all areas of the law. Pursuant to the statute, it is the responsibility of the prosecutor to provide notice and opportunity to crime victims at various stages of the judicial process. In a personal injury or burglary crime, the statute requires the prosecutor to notify the victim and provide an opportunity for the victim to provide comment prior to reducing or dropping charges or changing a plea agreement. This duty to provide notice and opportunity continues throughout the sentencing, release, and disposition phases of the process. The nature of our work requires collaboration. At the request of a crime victim, the Commonwealth has legal standing to assert and enforce a right enumerated by the Crime Victims Act. Collaborating with crime victims in this manner assures fairness, builds trust, and a sense of empowerment for those impacted by crime and engaging with a system that is often unknown to them. As prosecutors, it is never our intent to violate the rights of crime victims. But when a right is inadvertently missed or a notification is not provided, it is our privilege to work with crime victims to seek a remedy by filing a legal standing motion.
As the Executive Director of the Public Defender Association of Pennsylvania, I understand that our justice system works because all parties have rights recognized by law. As defense attorneys, we should be committed to securing a fair justice system and providing high-quality legal representation to people facing loss of life, freedom, and family. A part of that commitment includes understanding the rights afforded to crime victims and acknowledging their role in the legal process. We understand it is the role of prosecutors to provide crime victims with notice and the opportunity to provide comment at various stages in the legal process. And it is incumbent upon us as defense attorneys to be aware of crime victims' rights and how and when they should be upheld in the process.
Pennsylvania law has always supported crime victims' rights. Now, the law provides a remedy for enforcement of those rights as enumerated in the Crime Victims' Bill of Rights. Victims of crime now have standing to address rights violations before the court. Judges play a crucial role in this process. We have the responsibility to ensure that the law is upheld. When reviewing a plea arrangement, please ask, has the victim been informed of changes to the charges or the changing of a plea? Please ask, has the victim been given an opportunity to provide the prosecutor with comments concerning the plea? Before the conclusion of a case, make sure you have provided space for the victims to provide a victim impact statement to the court. When a motion is filed by either the prosecutor or the victim, which alleges a violation of one of the enumerated rights, please make sure your staff is equipped to follow proper procedures to address the motion. You see, as members of the judiciary, we have the privilege of ensuring the rights afforded to crime victims are upheld, and that when citizens of Pennsylvania are impacted by the judicial system, their experiences are in line with fundamental principles of justice and fairness.
Every day, countless individuals suffer the devastating impacts of crime. Their lives are irrevocably altered, their sense of security shattered. Yet too often the needs and voices of these victims are overlooked or marginalized. It is imperative that we advocate for victims' rights and ensure their well-being is prioritized. Victims deserve to be treated with dignity, compassion, and respect. They should have access to necessary resources, support services, and justice. We must work to create a society where victims feel empowered to come forward, where their experiences are validated, and where they are not re-traumatized by the legal process.
As you can see, that is a fantastic video, and we thank the Office of Victim Advocate so much for creating that, producing that, and making it available to all Pennsylvania communities. What we need you to do with that video, and again, we'll provide the link in the follow-up packet, we need you to share that, show that in your roundtable meetings, in your criminal justice advisory board meetings, in your communities, and for all communities and partnerships that you have, please share the video. And thank you so much. Our next segment deals with programmatic grant compliance and monitoring. We'll have Josh Kaminsky from Office of Victim Services and Maria Katulis to talk with us a little bit about quarterly reporting, the standards, and also monitoring processes for 2025.
Thank you, Heather. I'm going to go over the some changes with the quarterly reporting. I'm going to tell you right now, there is no tracking or reporting requirement changes. So whatever you're doing right now and you have been doing, you just keep doing it. What is going to change is when you're in eGrants to submit the numbers, and I'll share my screen. It's now going to be just like an Excel form. You just enter your numbers in and then attach. My screen comes up when you go into eGrants to do your quarterly report in the same program monitoring section. There'll be a template document there with instructions that says, hey, download this template. You'll download the template, and this document that I'm sharing my screen with will open in front of you. There are 3 tabs. The first tab has all the instructions, pretty much telling you what is needs to be entered in each section of the RASA and VOJO areas, and with the validation instructions. Like example, this January to March quarter everyone is considered new because we get a unique count for the entire year of individuals served. So everyone, the new and the total will match. And in this Excel sheet, there will be error checking and actual validation checking as you go through this sheet. So when you go through the instructions, it'll tell you where what needs to be entered in each of these sections on the following tabs. If I go to RASA, this is what the tab will look like. And then you will just type in your numbers and stats. You can hand it off, and you'll see it will start populating error checks as you start entering in your information. And then they'll clear when there is no error. And you will enter that in. This was done because the eGrants, it was kind of cumbersome to go into every individual section to enter your stats. This was found to be a little bit more easier as it's all in one location, and it's easier to, like, if you have another staff member that helps you with that. And then we have a VOJO section. You will just enter your stats in, and the color will go away as you're entering it. I have an example form here. As you enter, it will look like this when you're all said and done. And you would just save this and attach it to your program report in eGrants. These gray sections here will total for you automatically, and we did protect them so you won't erase the formulas. So don't be afraid of that. One of the questions I get with quarterly reporting in the victimization section every year, every quarter, is multi-victimization. What that is, and I have an example here. So in the victimization categories, it's the number of individuals who have who presented that victimization. The leading guidance we give is what's the lead charge on the case? That would be your victimization for the victim. Here's my example. If you have Abby, Ben, and Carol, who came in with the victimization of other terroristic threats, you have 3 individuals with other terroristic threats. Say Ben came in for another case, and it's a theft case. He's counted in the other theft. You have 1 individual who's a victim of theft. When you total this, you have 4 victimizations. But Ben is counted in more than one of these victimization categories. That means there is 1 person with a multiple victimization. Even if, say, Ben was in this section too, maybe there's a 3rd case. He has property crime. It will still be 1 because you have 1 individual who's counted in more than 1 cases. And that's what multiple victimization is talked about. It's just the number of victims counted in more than 1 victimization category. Are there any questions in regards to quarterly reporting or this form and submission process?
Josh, we did have one question. This is Valerie from Carbon County. Would we be able to create the Q1 program report now and download the spreadsheet that you're reviewing with us currently?
Yeah, if you went in to make your program report, it'll automatically come up in that when you go there to download that template document. And you can fill that all out just so you have. If you are also using the RASA VOJO tracking sheet that we have on our website, I know a number of agencies use it. That hasn't changed at all. And filling out that will actually help you. The reporting categories are matched right up with this sheet, and will also make it easy as well.
Great. Thank you, Josh. And Valerie, just know that we are still making awards on the 2025 RASA VOJO grants. So some people at this point wouldn't be able to get in and see that spreadsheet within eGrants. However, as we get a little deeper into March, we'll be sending out instructions with the spreadsheet so that you all know what to do when it comes time for the quarterly program report. We did get another question, Josh. Liz Foster writes, can you tell me how to get a copy of the RASA tracking sheet? And I think we can provide that. And I think we have a webinar already on YouTube that talks about how to enter information.
We can email you a fresh tracking sheet.
Okay, thank you. So I think we have Maria's PowerPoint up for monitoring updates and standards updates.
Thank you, Heather. My name is Maria Katulis. I'm a victim service specialist in the Office of Victim Services. Today I'll be discussing aspects of the monitoring process and also the Consolidated Victim Services Standards. The foundation for the monitoring discussion is the RASA VOJO monitoring tool, which is created in the eGrant system. The monitoring tool is composed of sections which each contain multiple questions. The more thoroughly you complete the monitoring tool, the smoother the process tends to go, with less likelihood of multiple issues to respond to after the monitoring. The first section of the tool is called the Monitoring Checklist and details additional documents that should be submitted to the monitor. Examples of these documents include notification letters, release of information forms, and policies. The Monitoring Checklist section also details personnel folder items, such as signed code of ethics, job description, etc., that need to be shown to the monitor. Finally, the monitor will ask you to provide a data backup for the number of a specific service or victimization which was reported and submitted in a quarterly program report. Please also be prepared to show the monitor your client data management system, for example, PMS, the Excel tracking sheet, etc. If you haven't already heard from a staff person, you're probably wondering if your agency is on the 2025 monitoring schedule. This slide has the link to the agencies which will be monitored in 2025. The schedule can also be found by searching compliance and monitoring on PCCD's website. You will be notified by an OVS staff member via email that your RASA VOJO grant is to be monitored. You and the staff person will then agree on a date for the monitoring. You will have at least 8 weeks to complete the monitoring tool in eGrants and to submit additional requested documents. As you work on the monitoring tool and the checklist of requested documents, your monitor will be available to answer questions by email or phone. Two pieces of legislation have been enacted which will be part of discussions during monitorings. The first of these is Act 71 of 2022, which elaborates on two specific victims' rights and relates to bail. First, the arresting officer is to provide the victim's name and contact information to the Magisterial District Court or the Philadelphia Municipal Court that is conducting the preliminary arraignment. The court is responsible for providing notices to the victim of any proceedings to modify bail conditions and their opportunity to appear in court if they desire. Second, at the conclusion of the preliminary hearing, the District Municipal Court is to provide the Court of Common Pleas with the victim's contact information along with a transcript of the preliminary hearing. The Clerk of Courts is then responsible for notifying the victim of any proceedings to modify bail and the opportunity for the victim to appear at these hearings. This applies to victims of the following offenses: a personal injury crime, a crime of violence, child sexual abuse and child pornography, and sexual exploitation of children. Some of the discussion points about this legislation are: how have these changes impacted your agency? And what have you done to improve communication among your agency, law enforcement, and the courts? The second piece of legislation that will come up during monitoring is Act 44. A foundational piece of Act 44 is to create an option of a probation review conference. This review process is driven by a probation status report and is available for certain qualifying defendants to determine if they will receive an early termination of their supervision. Required victim services include the victim shall be notified of the date and time of the probation review conference. Comment input may be given on the report and recommendation, and the victim shall receive accompaniment and advocacy and support as needed leading into, during, and after the hearing. The monitor will ask you how the probation review conference process is working in your county and how this process is impacting your program. Excuse me. Over the past 2 years, the Services and Standards Subcommittee of the Victim Services Advisory Committee, or VSAC, has been reviewing and updating the Consolidated Victim Service Program standards. You may have seen during that time, PCCD has notified the field of these updates via our OVS newsletter. As these updates occur, we ask victim service providers to review their policies and procedures to ensure they are meeting the appropriate updated standard. When your agency is monitored, PCCD staff will ask to review these policies and procedures for those standards that have been updated since the last monitoring. On the next slide, we will discuss the most recent updated standards. On February 4th, 2025, the Victim Service Advisory Committee approved updates to the consolidated standards. The updates affect the following RASA VOJO standards. The first of these is court security. The Victim Service Program, in coordination with court personnel, will assist the victim with safe movement to, from, and within the court facility. The VSP shall work with court personnel to provide a safe waiting area for the victim. The second updated standard is the criminal or juvenile case status. The VSP must provide accurate and timely information to the victim about the status of the case. The VSP shall have a procedure to identify conflicts among the parties. The third updated standard is confidential communications. VSP staff will rigorously protect all victim information except where disclosure is required by law or where an informed and valid consent is given by the victim. The next updated standard has a new name. It is now called Use of Technology in the Provision of Services to Victims and Client Data Management Systems. The standard is retitled to include Client Data Management Systems. VSPs are now required to have written policies and procedures regarding staff training, access, use, and management of databases and electronic systems used for client records and data. Another updated standard is court events. The court events standard incorporates newer legislation and the interface with court activities and victim participation. Our next updated standard is victim witness intimidation. The Victim Service Program has responsibilities with intimidation incidents to include notification, safety planning, which may result in relocation, and feedback on actions taken by law enforcement, the district attorney, and/or the courts. And our last updated standard from February 2025 is release, transfer, and escape notification. This standard recognizes technological advances for storage of offender victim information and in making victim notifications through PA7, the OVA registration portal, and other relevant databases systems. All victim service programs who have OVS as their oversight entity will be required to have updated policies and procedures aligned with these standards as of April 1, 2025. My information is on the last screen if you have any questions that you'd like to ask me. Heather, do we have any questions in the chat?
No questions in the chat pertaining to standards or monitoring. However, I'll just go back to Josh's segment. Brian put in the chat for the folks that were looking for the RASA VOJO tracking tool and video tutorial. Brian's put the link from our website in the chat, so it's available for folks to check out. And I think PCCD is in the process of scheduling all of our monitorings. So if you believe that you're due for a monitoring this year, we should be in touch with you definitely by the end of March to get that set up and to go over some of the things that Josh and Maria highlighted for us. Okay, it's going for noon. We thank you all for hanging with us for the next few minutes. We're going to turn things over to Tony Barber. Tony's going to talk to us about the upcoming Pathways Conference and the Pathfinder Awards.
Good morning, everyone. I've just shared a link in the chat to our Pathways Conference and Pathfinder Awards website. So please take a look at that on when you have some time. So the 2025 Pathways Conference is coming up this year, September 10th through 12th at the Kalahari Resort and Convention Center in Pocono Manor, Pennsylvania. We're going to have over 40 workshops and 3 keynote speakers, so you can easily get your full year's worth of training at the conference. And honestly, you'll probably have some to roll over to the next year. So our 3 keynote speakers for the conference, it's going to be Nicole Hockley. She is the CEO of Sandy Hook Promise. She's going to be speaking about a little bit about the Sandy Hook incident, but mostly about what the Sandy Hook Promise does for gun safety and control today. We also have Dr. Bernadine Waller. She is going to be presenting a keynote called Do You See Me? Delivering Culturally Responsive Care to Black Survivors. We're also going to have Waylon P. Pahona and Joanna Corpino, and they are presenting a keynote on self-care and healing. So keep your eyes open. Registration should be opening up here in very early March, hopefully in the next 2 weeks. Also, we are still taking nominations for the Governor's Pathfinder Awards. These will also be presented at the conference, so if you know any outstanding advocates who should be recognized, please think about nominating them. The nomination form is at that link that I put in the chat. So thank you for listening, and thank you for being here this morning, and we hope to see you there at the conference. Thank you.
Thanks very much, Tony. We look forward to all of the good things coming up at the conference. So with that, Emily's going to go ahead and place a program evaluation in the chat today. We ask that you just take a few minutes to tell us how we're doing and whether you like today's content. We recognize it was a lot of information and a lot of different speakers, but we hope this met your expectations. I want to thank all of our presenters this morning, and also a special word of thanks to Brian Swoyer, our program manager, who's been working behind the scenes to share all of the PowerPoints and the videos with us today. Please keep an eye out for future RASA VOJO meetings. Usually in the spring and the summer, we go on the road and we host regional meetings, so we will have details on future meetings in the OVS newsletter. I'll also give a plug to our Pennsylvania Victim Services training module. We do have some new courses available. Among them is the Providing Services for Asian Victim Survivors. And then also for directors and leaders who are working with the Board of Directors, we have 2 new courses. One is Board Basics for members, and then Board Basics for leadership. So there's an array of courses that anyone can take in the PVST training system, but those are just a few of our new offerings. Again, thank you so much to all of our presenters, Thank you to everyone who joined the call this morning. Just please take a minute or two before you log off the call to complete the evaluation. Thank you so much and have a great weekend.